Welcome to the deep dive. Okay, let's unpack this. We're diving into a really fascinating legal challenge today. It puts presidential power right under the microscope, specifically around tariffs and declaring national emergencies. You've shared some really compelling sources, articles, research detailing a federal court ruling. It directly confronts how a president used tariffs. So our mission today is to explore what happened, why this case is, well, frankly, so significant, and what it tells us about the balance of power. And this isn't just dry trade policy, right? It's really about how laws get interpreted and the limit on executive authority, even when claiming an emergency. Get ready for some key insights from these sources you've provided. Some of it might actually surprise you. Okay, well, let's start by setting the scene a bit. According to your sources, President Trump used tariffs, well, frequently. He even called himself Tariff Man. And often he linked these actions directly to declarations of national emergencies. Yeah, the reporting shows this pattern, foreign gain members, emergency. Mining companies, emergency. A protest, emergency. And tariffs seem to be his preferred response, quite often. Your sources highlight two main sets of tariffs that are key to this specific legal challenge we're discussing. First, there were the trafficking tariffs. These were imposed in early 2025. They hit goods from Mexico and Canada with a 25% rate, and China started at 10%, but that later climbed to 20%, the justification given, emergencies related to drug trafficking and border security. Then second, you had the worldwide and retaliatory tariffs announced in April 2025. This was broader. A 10% tariff on imports from, well, pretty much all countries, and even higher rates up to 50% on some specific nations. And these were justified by saying trade deficits were threats to national security.
What's really striking here, looking at the sources, is just the constant change during that period. Frequent executive orders, rates changing, timings shifting all the time, pauses, new exemptions popping up. The reporting suggests that during this time, tariff policy often felt highly reactive, almost tied to the president's public statements or focus at that exact moment.
Right. And that shifting sort of personal feeling approach, that's what triggered the legal challenge. You shared that a group of small businesses actually sued, arguing these tariffs were, well, crippling them.
Exactly. The sources really detailed the complaints from specific companies: VOS Selections, Genova Pipe, Microkits, Fish USA, Terry Cycling. These names pop up. And they weren't just, unhappy. They alleged serious economic injuries. We're talking real-world stuff. Trouble sourcing materials, prices becoming totally unpredictable, cash flow getting squeezed, which it's inventory purchase orders, and a genuine fear for some of being forced completely out of business. So their core legal argument, based on the sources, was that the president had just gone beyond his legal authority, specifically under the International Emergency Economic Powers Act, AIPA, and that his actions also violated the Constitution.
Okay, so the lawsuit's filed. Where did this fight actually happen? Which court?
The sources point to the U.S. Court for International Trade, the CIT. And this isn't your standard local federal court. It's specialized. It's an Article III court, same basis as district courts judges appointed by the president, confirmed by the Senate. But its focus, its exclusive jurisdiction, is international trade and customs law. So tariff cases, they land here. And unlike most federal courts, it actually has nationwide jurisdiction. The sources mention it typically has 9 judges, and there's a rule: no more than 5 can be from the same political party. Kind of interesting.
And this case wasn't decided by just one judge, right? It needed a special panel.
That's correct, because the case directly challenged the constitutionality and statutory authority behind a major executive action. These tariffs, federal law mandates a 3-judge panel. Yeah, the sources name them: Judge Timothy Reif, a Trump nominee; Judge Jane Rustani, a Reagan nominee; and Judge Gary Katzman, an Obama nominee. So a mix. This panel reviewed everything and ruled on what's called summary judgment. That means the basic facts weren't really in dispute, like, yes, the tariffs happened, yes, the companies were affected. The fight was purely about the legal interpretation. Did the president have the authority?
All right, so the businesses say the president overstepped. How did the administration defend using these emergency powers and these specific tariffs? What was their main argument in court?
Well, the sources indicate they leaned really heavily on AIPA, the International Emergency Economic Powers Act. Their argument was basically that AIPA gives the president really broad authority to regulate international commerce when there's an unusual or extraordinary foreign threat. And they claim these threats: drug cartels, human traffickers, even foreign governments with trade practices they didn't like, qualified as those kinds of emergencies. So for the trafficking tariffs, the logic was, we need to pressure countries that aren't stopping drug flow. For the worldwide tariffs, it was framed more as a response to, long-term trade imbalances, unfair practices, things they argued endangered national security. And interestingly, according to the sources, there was a bit of a shift from public statements. While President Trump often said publicly that foreign governments pay tariffs, in the actual court filings, his administration acknowledged that legally, tariffs are taxes paid by the U.S. businesses importing the goods, which, of course, often get passed down to consumers eventually.
And didn't the president also argue that the courts shouldn't even be questioning whether an emergency was real? That it was sort of off limits?
Yes, exactly. The sources mention they tried to use the political question doctrine, essentially arguing that deciding if a national emergency exists, particularly one tied to foreign affairs or national security, is a political judgment. It's inherently something the executive decides, not the courts. They basically said, look, the president declared an emergency. The court shouldn't second-guess that declaration.
Okay, so that's the administration side. How did the court respond to all that? What did they find wrong with using AIPA this way? Especially this idea that just saying emergency is like a cheat code, as the sources put it.
Right. And that cheat code language comes up. This is really the core of the court's legal reasoning, according to your sources. They flatly rejected that idea, that declaring an emergency under AIPA gives the president unlimited power. Just wasn't buying it. Here's the key takeaway, really. The court stressed that AIPA lets the president regulate property transactions in response to a foreign threat. But it absolutely does not grant, blanket authority or unbounded authority, as they termed it. It doesn't let the president just impose any tariff on any country for any reason at any rate they choose. There are limits.
So even if you accept there is an emergency, AIPA still has specific guardrails on how the president can respond.
Precisely. The sources explain the court went back to basics. Standard legal interpretation methods, guided by big principles like the non-delegation doctrine, the idea that Congress makes the big laws and can't just hand off its core power, and also the major questions doctrine, which basically says if an agency or the president claims some huge new power with massive economic or political effects, Congress has to have granted that power really clearly in the law. And the court looked at using AIPA for worldwide tariffs up to 50% and said, whoa, that's a massive decision. And AIPA just didn't clearly grant that kind of sweeping authority. It wasn't specific enough. The court also looked at history, presidential emergency powers. Specifically, they looked back at the 1971 temporary tariff Nixon imposed. That was under an older law, the Trading with the Enemy Act, TWWA. Courts upheld that one, but only because it met very specific conditions. It was temporary, tied to a specific economic emergency back then, narrow in scope, and seemed consistent with what Congress intended at that time.
Ah, okay. And Congress actually reacted to Nixon using that power later on, didn't they? They changed the laws.
Yeah, they did. Big time. The sources highlight this. Congress later restricted TWWA powers just to wartime. And then they created AIPA specifically for national emergencies other than war. And crucially, the legislative history, the records from when Congress debated and passed AIPA, showed Congress intended AIPA to give the president more limited powers than the old TWWA and subject to more procedural checks and balances. So the court saw the Trump administration's argument that AIPA was somehow broader than TWWA as completely backwards. It just didn't align with what Congress intended when they wrote the law.
Okay, that makes sense. What about using AIPA specifically for trade deficits? That was the reason given for the worldwide tariffs. Did the court buy that?
It's another really key point the court tackled. The sources explain it pointed to something very specific. Congress had already made a law dealing directly with trade deficits and balance of payments issues. It's Section 122 of the Trade Act of 1974. And Section 122 gives the president a tool for those situations, but it's a limited tool. Tariffs or quotas, yes, but capped at 15%, and only for a maximum of 150 days. So the court's reasoning was, if we interpret AIPA to allow unlimited tariffs for trade deficits for however long the president wants, well, that basically makes Section 122 completely pointless. It overrides it. And courts really try to avoid interpreting laws in a way that makes other law meaningless. That's a basic principle of statutory construction. So the conclusion was, Section 122 is the specific tool for economic imbalances. AIPA is for genuine foreign emergencies impacting property. Using AIPA here, blowing past Section 122's limits on an issue Congress already addressed, unauthorized.
Got it. And the trafficking tariffs, the argument was they dealt with drug trafficking. What did the court say about that connection?
Right. AIPA has this requirement that whatever action the president takes must actually deal with the specific threat that triggered the emergency declaration. The sources say the court looked at the trafficking tariffs basically using trade policy as leverage and found that didn't really address the threat of drug trafficking itself. The court felt the action taken needs to have a reasonable relation to fighting the actual threat. Just using tariffs as general leverage against countries, that didn't meet the standard in a meaningful way. The court argued that if that counted as dealing with the threat, the requirement would become almost meaningless. Anything could be justified as leverage. And finally, they tackled that political question argument head on. The sources indicate the judges were pretty clear. Their job is to interpret the laws Congress writes, even when those laws touch on politics or executive actions. They explicitly stated they don't just unthinkingly defer to the executive branch simply because an emergency is declared or foreign affairs are involved. The court determined that AIPA does not say that whether the president's action actually deals with the threat is solely up to the president's judgment. That's something the court can and must review to ensure the law is followed.
Wow, okay. So pulling all that legal analysis together, the final ruling was.
The court ruled decisively for the businesses, the plaintiffs. According to the sources, the court vacated the Trump tariff orders, basically nullified them, the ones based on AIPA, and they permanently enjoined their enforcement, blocked them from being applied. The conclusion was clear. AIPA is not, as your sources phrased it, a cheat code for unlimited tariff power, and it can't be used to just bypass specific limiting laws like Section 122.
That is a really significant ruling.
Yeah.
So what happened right after? Was there an immediate reaction?
Yes, swift reaction. The sources say the Trump administration immediately filed a notice of appeal, taking it up to the next level, the Federal Circuit Court of Appeals. And the Federal Circuit quickly issued what's called an administrative stay. Think of it as a temporary pause button. So this means the tariffs actually remain in effect for the moment, while the appeals court decides on the government's request for a longer stay, one that would last through the whole appeal process. The sources noted a really fast schedule for arguing about that longer stay. The businesses had to respond by June 5th, the government by June 9th, so a decision on that should come relatively soon. But the full appeal itself, that could take quite a while. And then, after the Federal Circuit rules, a further appeal to the Supreme Court is possible, though never guaranteed.
And how did President Trump himself react to this initial court ruling, according to the sources?
The sources reported he responded publicly using social media. He posted messages stating things like, "Nothing can stop what is coming," and that he was on a mission from God. He also added that God loves tariffs. The sources interpreted these comments as signaling his continued defiance and resistance towards the judiciary on this issue.
And what about the markets? Did Wall Street react to this?
Interestingly, no. The sources point out that the stock markets didn't seem to have much of a reaction at all to the ruling. They speculated this might mean the market either wasn't taking this specific legal challenge all that seriously, or maybe these particular tariffs weren't seen as a major factor for the overall economy anymore. Hard to say for sure.
You also shared some really interesting analysis to your sources about the media coverage of this ruling, how the story itself was presented.
Yes, and this raises that important question, right? How do complex events like this actually get filtered down to us, the public? The sources noted really extensive coverage. Over 350 different sources reported on the ruling, and they provided a breakdown of the, let's say, perceived political leaning of these sources. Roughly 30% from the left, 45% from the center, and 25% from the right.
And the headlines themselves told different stories, depending on that leaning.
Exactly. The sources gave examples of how the headlines framed it quite differently. Left-leaning sources often focused on it as a personal loss or setback for President Trump, sometimes using pretty strong words like humiliated. Center sources tended to report more straightforwardly on the court's findings, tariffs rule illegal or president exceeded powers. More direct quotes from the ruling. And right-leaning sources, according to this analysis, were more likely to mention the court's location, calling it a New York-based court. The sources suggested this phrasing might imply a kind of regional or political bias behind the ruling itself. The sources also highlighted what they called a blind spot example. There was a related story going around about how Trump's tariffs had apparently led to a big drop in U.S. tourism, costing billions in revenue. According to the analysis you shared, this specific tourism impact story was completely ignored by right-wing media outlets. Coverage only came from left, about 40%, and center, about 60% sources.
Wow, that really underscores how different news outlets can paint vastly different pictures of the same reality for their specific audiences.
It absolutely does. This analysis, pulled straight from your sources, just highlights how much media framing matters in shaping our understanding and why, getting multiple perspectives is so crucial if you want the full picture.
Okay, that really was a deep dive. We've unpacked the president's actions, the justifications, the court's very detailed reasoning, digging into specific laws, congressional intent, And even how the news about it all got reported across the media landscape is quite a story. And it's such a powerful reminder, isn't it, that even actions taken under this broad claim of national emergency are still subject to legal limits, subject to judicial review. It reinforces that whole separation of powers idea.
Absolutely. And what's so insightful, I think, is how the court didn't just make some vague statement. They zeroed in on specific laws like Section 122 of the Trade Act. And they used the actual legislative history, the records of Congress debating AIPA, to show Congress had already thought about these issues and deliberately limited the president's power in these areas. So AIPA couldn't just be used as an end run around those existing limits.
So what does this all mean for you listening? Well, it shows how these seemingly technical legal rulings, things about trade policy, tariffs, they're deeply connected to fundamental questions. Questions about the balance of power in our government, about how laws actually get interpreted and applied in the real world, and, as we saw with the media coverage analysis, how we even perceive these big events can be heavily influenced by where we get our information.
Yeah, it raises a really important question for you to maybe chew on after this. How do different interpretations of the very same law, depending on whether it's the executive branch or the judicial branch doing the interpreting, lead to such vastly different outcomes? Outcomes that affect businesses, consumers, the whole economy.
Think about that. How this one specific case stemming from these tariff orders really gives us a window into that ongoing tension, the push and pull between the executive and legislative branches, and the absolutely critical role the judiciary plays in trying to mediate that tension by interpreting the laws Congress passes. Thank you so much for joining us for this deep dive into your sources. We really hope this has given you a clear, maybe more informed understanding of this complex ruling and all the dynamics swirling around it.